Hello, my name is Juli. I am an associate in the infrastructure team, and today I will be discussing navigating long-term public-private partnerships. There has been a recent rise in court cases recently concerning PPP contracts, and it is probably no coincidence that at the same time there has been much cynicism in the press and publications about such contracts, particularly in light of the insolvency of outsourcing giant Carillion. There have been 3 cases in the last 12 months seeking judicial interpretation of clauses in PPP contracts. The first one I'm going to look at today is the Connect Plus versus Highways England case of January this year. This concerned a 30-year design, build, finance, operate contract for motorway improvement, and the dispute there was about the definition of the term critical incident in the contract. The contractor's assertion was that in post-contractual discussions it had been agreed that the contractor, was going to be granted the power to make declarations as to whether a critical incident had occurred. However, when this was brought to the court, it was held that on a true construction of the relevant wording, that assertion was incorrect, and in fact the power remained with the Secretary of State to declare as to whether a critical incident had occurred under the contract. On the facts of the parties' conduct, the court felt that there was insufficient evidence to show that they had in fact reached an agreement on that issue. The judge said, "The contract has a duration of 30 years and it would not be just to restrict either party to an imperfect understanding of its terms." The second case I'm going to look at today is the Amy versus Birmingham City Council case of February this year. This contract was a 25-year private finance initiative, PFI contract for, again, road maintenance. The dispute there was whether the contractor was obliged to update the road database that was originally provided to it by Birmingham City Council to reflect the actual extent of the road network, and then to provide services in relation to that updated network. The contractor's assertion was that it was only required to service the smaller original network of roads that had been provided in the council's 2008 version of the inventory, but the court held that that assumption was wrong, and the judge said in his judgment that any relational contract of this character is likely to be of massive length, containing many infelicities and oddities. Both parties should adopt a reasonable approach in accordance with what is obviously the long-term purpose of the contract. They should not be latching onto the infelicities and oddities in order to disrupt the project and maximize their own gain. This brings us backwards to February 2017 and the case Glen Water versus Northern Ireland Water. In this PFI contract for the upgrading of sewerage services, a 15-year contract, the dispute there was whether a compensation event had been properly notified by the contractor to the authority. The judgment here largely depended on the facts of the case, and the judge reached the same conclusion as the adjudicator had previously reached, that the requisite notice for the compensation event had not been properly made because the alleged notice referred to a different event, in fact, not the one in question. In the judgment, the judge said the contractual terms are clear and commercial certainty is an overarching consideration. It seems to me likely that the notification requirement was overlooked amid a mass of claims and in the midst of an ongoing process of discussion. The lessons to be learned from these 3 cases: firstly, the pitfalls of complex documentation and in particular complex notification mechanisms. The seemingly logical and sensible practice of holding a meeting between contract parties to discuss a range of issues with varying degrees of severity, and then writing to each other purporting to cover multiple issues, does become a minefield one has to be wary of. This is more or less what happened in the last 2 cases, in the case of Glen Water and in the case of Connect Plus. Assumptions that notices had been given and agreements had been reached were made, but in both cases, the court was reluctant to gloss over these assumptions and demanded that the claimant, in both cases the contractors, showed a clear and unambiguous notification or resolution, which they couldn't on the facts. In the Birmingham case, the court took a different approach but reached a similar outcome, honing in on the reasonable approach in light of a long-term relational contract, rather than allowing the contractor to adopt a strict reading of the wording of the contract, which would have provided it with a loophole to reduce its obligations. The first lesson learned here is that the court acknowledges that such contracts are complex and managing them is not easy, but it does not excuse the parties from their contractual obligations. Therefore, careful contract management from the outset is very important. Notification requirements are very easy to trip up on, and we often prepare for clients useful things like user-friendly contract manuals, flow charts on processes that would help to understand and help people managing the contract to understand what their obligations are and what needs to be done. In a contract period of such length, it is important to remember that personnel on both sides of the contract is likely to change. Also, another useful thing to remember is following contract management meetings between parties, written accounts ought to be carefully drafted and be clear, and it's important to be clear about separate issues. You never know if that letter or that minute may end up as evidence in court one day. We're not suggesting an adversarial stance, simply the reminder that in light of the longevity of these contracts, it is worth spending time making sure you know what's expected of you for the next 20 or 30 years, and having a true record of the parties' intentions and the understanding at that point in time. This is particularly important in light of increased scrutiny of major outsourcing contracts recently. It's important for parties to be confident about the mechanisms within their contracts and any intricacies they need to be aware of. Thank you for listening. If you are interested in a more detailed discussion of the cases I've mentioned here, please refer to our website. And if you would like to speak to someone about the management or running of a PPP contract, a member of our infrastructure team would be happy to help.